Hi, I'm Sam Margulies and I'm a divorce mediator. And today I want to tell you about divorce mediation. But before I can do that, I have to give you a few basic facts and a little bit of history about divorce itself, so you can understand how mediation relates to conventional divorce. When you get a divorce, you're asking the state, through its court, to dissolve your marriage. And in exchange, the state wants to know three important things. The first issue concerns your children if you have them. The state wants to know how you're going to take care of your children, what kind of arrangements you're making, and what kind of parenting schedules you have. We refer to all those issues as custody issues. The second are issues of support for the children as child support, and perhaps support for a spouse, generally known as alimony. The third issue is the division of your marital property, so that the state is not worried that the matter of title to property is confused. Now, if you resolved all those three issues and you put them down on paper in a document generally known as a property agreement or a settlement agreement or a divorce agreement, you then have what we call an uncontested divorce, no contest. Now, you may be concerned about grounds for divorce. Grounds are the reasons that you offer the state why it should dissolve your marriage. As a practical matter, no one fights over grounds anymore, and I'll tell you a little bit more about that in a minute. What divorce concerns primarily today are the three issues I described: custody, support, and property division. So the question is, how are you going to resolve those issues? Now, the way you did it in traditional divorce is you each hire a lawyer, and the lawyers fight. If you don't agree on the issues, the lawyers are preparing for a trial at which a judge will decide all those issues. But to get a case to trial can take 2, 3, 4, 5 years and cost upwards of 6 figures. In the meantime, you're sitting, waiting, and spending a lot of your money. Now, there's an important fact that most of your lawyers don't want you to know. Maybe 1% of divorces go to trial. All the rest, 99%, get resolved by a negotiated settlement. You may have paid tens of thousands of dollars to prepare for a trial, and you may have waited in limbo all that time. And then you're surprised when, just before the trial, the case gets settled by negotiation. Now, this is a very screwed up system. It hurts families and helps lawyers. If settlement is the absolute norm, then trials are the pathological exception and occur only when somebody in the system, one or more of the lawyers or one or more of the clients or all of them, are simply nuts. The adversary system of law does not fit modern no-fault divorce. Now, before 1960, divorce was all fault-based. What that means, or what that meant, was that the spouse seeking the divorce had to prove that the other spouse had engaged in bad behavior that made it unreasonable to expect the victimized spouse to stay married. These fault grounds were adultery, desertion, chronic drunkenness, extreme cruelty, insanity, and a few others. But after World War II, and increasingly into the 50s and 60s, increasing numbers of married people wanted to be able to divorce, not because somebody had done anything terrible, but simply because they were unhappy. But unhappiness does not fit into the system of fault-based divorce. Now, in response to that, state legislatures began to adopt no-fault statutes. If you could establish that your marriage was dead as a practical matter, you could divorce. In some states, it required a period of separation, whether it was a year or 2 years. In other states, all you had to do was establish that the two of you were incompatible and could not live together in peace. All states now have one or another of a no-fault statute, so that everybody has grounds for divorce if they want to leave a marriage. Now, the adversary system was designed to prove who was at fault. The premise in that system is that two advocates would each present the evidence most favorable to their client, and a fact finder, a judge or a jury, would find the truth: guilt in criminal cases, liability in civil cases. The system assumes that if the trial is properly prepared and conducted, truth will be told. But it relies on the trial to get to the truth. But what happens if the case doesn't go to trial? If 99% of cases are settled without a trial, what logic is there in preparing the case to go to trial in the first place? It costs a lot of money, and it wears you out not only financially but also emotionally. Now, this was a situation in 1978 when I started practicing law. And after a while, increasing numbers of lawyers were asking, isn't there a better way to go about helping a couple settle their divorce? If the case is going to settle anyhow, why spend all those years and thousands of dollars preparing for a trial? Why not start out by settling the case? And the answer that arose was divorce mediation. For more information on any of these topics, go to my website, follow me on Twitter, Facebook, look at my books on Amazon, or if you'd like, call me.